everybody. We'll call this meeting to order. This is the Scott County Fiscal Court June 25th business meeting. I'm glad to see you all here. We can really see you now. It is bright, and we've got new improved LED lighting. Well, we're going to talk about that. But no, we're glad that you're here, and we appreciate your attendance. And I would like to ask you to join me in the Pledge of Allegiance. Let us pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Hamilton, will you call the roll?
Mr. Hostetler?
Present.
Mr. Jones?
Here.
Mr. Wallace? Mr. Corman? Present. Mr. Ellison? Mr. Pratt?
Here.
Mr. Livingston?
Here.
Mr. Livingston?
Here.
Mr. Willis?
Here.
Judge Cuttington?
Present. Let the record reflect that we have a quorum and we can conduct business, take action. With that said, the first item, did you have Dr. Wallace as in attendance? So let the record reflect he's live, and he's not live, he's virtual from Ireland. I don't know exactly what. Chad, where are you at in Ireland with your family? All right, we got all that.
It's in a fishbowl.
So with that said, the first item for consideration are the minutes from our previous meeting, and any questions or comments related to those minutes as presented. Motion. Second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Next item, number 5, transfers as presented by our treasurer, Michelle Ray. Any questions related to those transfers as presented? Motion from Kelly Corman, second from Rick Hostetler. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Bills and hand checks as presented. Any questions or comments?
Motion.
Motion from Rick Hostetler.
Second.
Second from David Livingston. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. That leads us to number 7, MOU between the fire department, EMS, and the state of Kentucky. Chris, John, would you all make any comment on that MOU? And do you have anything to add?
Judge, magistrates, this is basically an MOU between EMS, fire department with the state. They recently formed a Kentucky USAR team. So, they've got team members from various departments throughout the state of Kentucky. So basically this group will, any disasters or whatever that get called up, they would be able to respond with this group.
Can you just, for everybody that doesn't know that acronym,
It's
Kentucky Use?
Yeah, Urban Search and Rescue.
Okay,
Yeah.
Urban Search and Rescue.
So the state of Kentucky's never to this point had one. I think the closest is Indiana and Ohio basically have a task force team. The state of Kentucky now has this team. This will take effect July 1, and it's a 2-year commitment. We have one member of our department. You have two that would be a member of this team. So basically, we just have to have them available if they were called up to be able to go and respond with that team. Also, part of this is they're required, I think, to do 6 trainings throughout the year with that You know, like our guy specializes in hazmat is what his specialty is as far as the team goes. So that's a part of this agreement as well. Any deployments are 100% paid for. We'll pay them initially, and then we would basically get reimbursed back from the state for their time that they're away. That also not only covers their time away, but any backfilling that we have to do for those members, it would cover those expenses as well.
So, Ben, you said you might have some comments to share as well.
I do, thank you, Judge. So in my review of this, it looks like with respect to your comments, sir, about the recompensation from the federal government, the only thing that caught my attention was that it appears that the receiving agency, in this case, Georgetown, Scott County Fire, et cetera, would be responsible for doing audits and for keeping a financial system in place to, I guess, keep track of how much in grant money they were receiving. Not that that's necessarily a good or bad thing, it's just something that caught my attention as a requirement. Do y'all have any plans for that?
I think as far as grants go, we have audited on those, correct? Yeah.
Rob Jones?
On the trainings, John, would they be local, statewide,
There
be
is.
anywhere in the country?
Like, for example, I know our member, there's a training that he needs to go to in Ohio. It's in Ohio. But I think they try to do it state, but some of the specialties things they may have to send to wherever it's offered.
Rick, so if we sign on with this, so that, say there's an event here in our county that team says, hey, we're coming.
Yeah.
So, but if we didn't sign on and there's an event here in our county, they would still come? I'm just,
Yeah, they would.
yeah. So, but we're making a commitment to take off and go help another community if the need arises. Okay.
Yeah, one of the big advantages for John and I's department is our folks will be able to attend this training and then bring it back to our folks. So even though they're not part of the team, they'll still be able to, get some of that training folks that we send away for us.
And this has been a big push for years with the state of Kentucky on getting a certified team, at the state level. Because a lot of times, it was, we could potentially get a task force team in from another state into Kentucky if we had some kind of disaster, or it would be just basically fire departments helping other fire departments and sending help is what it is. This kind of basically, establishes a team for the state of Kentucky that they've never had. And, and it also allows us to seek reimbursement, if our members go out or we're backfilling for their, absence.
Well, and going back to his concerns on the on the audits, it sounds like that's done in-house here, right? And I guess what I'm saying, it sounds like all the costs are going to be covered if we respond.
Yeah, and any of the deployments we make is all tracked through emergency management on the FEMA forms, so it's all accounted for.
Why is, I just lost it. Where EMA, is EMA involved in this? Can they be? Because they get deployed a lot. Why would we could get reimbursed for their, right? Do y'all get what I'm asking? Are they just not involved? I didn't see any EMA agencies listed at all.
No, I didn't either.
I don't.
So is it just? I mean, just a
They
question.
do get reimbursed when
They do.
maybe it's a different program.
Well, no, Louisville Metro EMA's on here. So I don't know. I don't know if we get our EMA on here.
I don't know. I don't see Mike here today.
Mike's always here.
Yeah.
But did you all volunteer for this, or they come to you all? They asked you all.
Basically, Kentucky USAR put out an email to, statewide, because like I said, they're trying to form this team. They wanted to know who's interested in being on the team. And basically, members had to submit applications to be on the team. And then ultimately, they made decisions and put people in places where they felt they needed to be. But they basically got accepted to be on the team.
I'd make if nobody says, but I'd make a motion to accept the MOU. I mean, I think it's a good thing, if we ever need it. So you're looking more like
Plus
flood
it
stuff.
enhances our training, which should enhance the safety of our community. So I'll make a second.
We have a motion and we have a second. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Thank you. Thank you all. Number 8 on the agenda, sheriff surplus donation, 2014 Ford Explorer, and it's going to Leslie County, I believe. Sheriff Nettles, how are you?
Good, sir. How are
You
you?
could speak to this one.
Good evening, Judge and Magistrates. It's a 2014 Ford Explorer. We've had it since 2014. We got it new. The frame's pretty severely rusted, kind of unsafe for us to operate anymore. I've had a friend of mine reach out to me from the Leslie County Sheriff's Office that needs vehicles, and I think this would be a dependable vehicle for one of the school resource officers down there.
Questions or comments?
Motion.
Frame issue, would we be responsible for anything?
As is.
Okay.
Motion from Rick Hostetler.
I'll second.
Second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Thank you, Sheriff. EMS new hires, Jeff Mudrap.
And Chief Runyon.
And Chief Runyon.
Okay. Yes, I'm pleased to recommend on behalf of Chief Runyon, 6 new hires. 3 of these will be moving from part-time to full-time status, and then we have 3 more coming on part-time. The 3 employees moving from part-time to full-time will be Kevin Ducker, Ryan Rumick, and Dylan Hall. They will make that change on July 6th, and the new pay rate for them will be $15.11 an hour. And those are the 3 positions that were approved as part of the budget process for this upcoming year. So that's to fill those positions. And then in addition to that, there are 3 part-time people that they want to hire. They'll all be starting at the $14.53 an hour, which is the new rate for the new fiscal year for part-timers. And they'll start on July 6th as well. And that's Nicholas Kelly, Elizabeth Ramsey, and Eric York.
Questions or comments? Motion from Rick Hostetler. Second from Kelly Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Road Department new hire with
Yes.
Jeff Mudrack and J.R. Brandenburg.
Yes, all right. Well, and this is, a lot of it is JR this time, because he has met Jimmy Cummington in the past and recommended him for employment.
No
We had
relation.
No relation. We did have a good discussion with him, and he comes highly qualified with about 30 years of experience in the field. He already has a CDL license, which is a plus. He will begin employment at $26.72 an hour, and he'll begin with us on July 13th. So that's the recommendation for you.
Questions or comments? Motion from Rob Jones, second from David Livingston. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. JR, that leaves us 2 down,
Still 1 down.
1 down.
Yeah,
I'm
1
sorry.
down.
All right. We'll
Okay.
keep working.
The next one is the chief electrical inspection position. Didn't know if you wanted to talk about this or me to take it.
I wanted to, just kind of lead the conversation off. This is a very important aspect of the services that Scott County provides to the community. And, we've been blessed. Don Hawkins has led that agency for 30-plus years, and he is retiring, as we've shared, 1st of October. So, we had a committee that interviewed some applicants, and a gentleman that worked for us previously then left a couple years ago and went to the Franklin County school system to lead their electrical education, their CTE program for electrical in Franklin County. Alan Neal is the candidate that the committee has recommended to the fiscal court. Alan brings a wealth of knowledge not only about the code, but he's also an experienced leader, and I think one of his strengths is relationships, communication, professionalism, and I just really feel confident as well that he will be able to move that department forward with modernization, using City Works, and you know, I've had a couple of y'all mention a few things to me that you all would like to see in the agency. So I think Alan will come to the table and really lead the department. You know, and when you lose someone that's been there for so long, like Don, you have to have good leadership, and I'm very confident that Alan will do that. You want to add anything to that those comments?
No, I think that he was a standout candidate for the position, and the other particulars is that his starting pay will be $93,000 a year, and he'll begin employment on August the 10th, and we'll have about 8 weeks overlap between Alan and Don to make sure we have a smooth transition there.
Very, very, grateful that we have a good candidate that can step in. So, any questions or comments?
Can I say anything? I'm gonna have to recuse myself.
Yes, sir.
Because of my day-to-day dealings with the office, but I don't know if I can talk about him or not.
Yeah, you can.
I don't know if that's-
I think.
You know, Alan is a good candidate. He's a youth minister at his church. He's already leading in the public, in our communities. I think he's a very good choice for the office, being he's already been there before, so.
I appreciate
But I
that.
will recuse myself.
No, and I respect that. Anyone else, comments or questions?
Judge, maybe a
Rick
comment.
Costello.
A comment and maybe a suggestion as well. Back to Don Hawkins. I've known Don for almost 50 years, and he's just a quality guy. And he's done a lot for this county. And he used to be on city council years ago, but for electrical inspections, he's done a lot, and he'll be missed. But for Mr. Neal, I'll make a motion that we hire him. But for him, I would make one suggestion. A lot of the surrounding counties, and it's a little bit different, but they're moving more to online, buying your permits, doing a little more activity online. It's different in every county, but I just suggest that he look into that because it can kind of streamline and help his office, I think, and the contractors.
I think he would value a conversation with you.
Yeah, be glad to do it.
I think he's that type of guy that.
And since I do work in the county, but I'm not currently and haven't for about 8 years, I'll make that motion.
Motion. Second from Kelly Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. With that said, we'll move to Human Resources new hire.
Yes, we are pleased to recommend the promotion or movement of Cassandra Shields from part-time to full-time status on July 6th to fill the HR payroll specialist position the court approved during the budget process for this upcoming fiscal year. The new pay rate will be $26.17 an hour.
Questions or comments? Would there be a motion?
Motion.
Motion from David. Second from Kelly Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes.
All right,
Thank you.
thank you.
Yeah. So a lot of work's gone into those. Number 13, Bell Engineering proposal. This started kind of underneath leadership from the city and conversations with them, and they had conversations with Bell Engineering, but they reached out to me and asked, since some of this signage would be out in the county, not in the city limits, they asked if we would consider taking the lead on the project and just the contract being with the fiscal court. Shared that with you all and feel like it's appropriate. I also want to share that, tourism, I've talked with Maury Saunders, and tourism is, their board has supported, helping pay for a third of the professional engineering proposal that I've shared with you all, just to kind of get to the point where we can have some choices about, I think that this proposal will offer up 3 versions of gateway signage. And I also talked with Devin Golden today from the city about the possibility of flexibility. There were 4 sites listed. You have to put down, like, you can't have an endless number of sites, but they did say that Devin did feel like there was flexibility looking at, exact sites for the siting of the gateway signage. Questions or comments about the proposal? Would there be a motion?
Well, I would just like to say I would like to model after Bowling Green, Kentucky, Warren County, Western Kentucky University.
I think our
I
budget.
don't know if you've
might-
ever been down 65,
Yeah.
but it is the most phenomenal job of welcoming into a community.
And that, I've actually been to a presentation on that. I think you've sat in that same presentation. And it's a very large public-private partnership with a lot of private donations. And if that's the direction that we want to go, we can go that direction.
I make a motion to approve.
Motion. Second from Ryan Pratt. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. That leads us to ordinance 2604, first reading. This is accessory dwelling units. I will go ahead and offer any opportunity to anyone in the audience that might want to make public comment about any of these next 3 ordinances: the accessory dwelling unit, the rural cluster subdivision preserved acreage, and the cluster subdivision text amendment ordinance as well. And, we've met about this about 3 times. We've had public comment and work session for just public comment. And I do want to speak to the rural cluster subdivision preserved acreage ordinance. Darcy, I sent back to Soil Conservation District that information. I hope you all got that.
Yes.
And just wanted y'all to have that in your hands before the meeting, and responded to your all's email as well. So I will, we'll be happy to take any public comment before we go forward. So open it up to anyone that would like to comment.
Got for all 3 or just?
For all 3, any of the 3.
I'll start. I have no comment on the first one. The second one, the preservation of acreage, it pretty well sets it out that it's locked in, it can never be annexed, or if it's annexed, it still be locked in. But then in the third one, it has specific language in section T and section W, which says if it's annexed, the I'm trying to figure what word they used. Basically, it could be the covenant will be reversed.
So the rural cluster subdivision 2605, that language supersedes any language that is in 2606. And if we change the language in 2606, we'd have to send it back to the Planning Commission. And this ordinance is a standalone ordinance from the fiscal court that will supersede that language about.
No, I'm all in favor of that. I didn't know the legalities of that.
And I would lean on Ben to speak to that as well.
So,
And Cam is on vacation, but Cam has talked to Ben.
Okay.
yeah, so I am less familiar with these ordinances and the nuance of them as the county attorney who drafted them, but I am familiar with them while he's out. I think I can answer your question. So, Ordinance 2605 contemplates the creation of a conservation easement which will run with the land. And it sounds like your concern, sir, is that if the land is eventually annexed, that conservation easement will be somehow reversed?
Well, that's what I hope an attorney will not argue before the court. That, well, it says here that it's reserved as a conservation easement, but it says in the other ordinance, if it's ever annexed, and I'm looking for the word again, I used it once.
If you could point me to the section you're most concerned about, that would be helpful in the analysis.
Do you have a page number on there?
Yeah, it's page 11.
And you're referring to 2606, sir?
26, it's the third one
06.
of the three. Yes.
You're talking about 06?
Let me look back. Yes. Well, it doesn't have 2606
page
on it,
11?
but it's the third one. It's the,
Letter T on page.
Are you talking about the one with preserved acreage or not?
He's talking about 26.6, letter
So
T and W.
I'm looking at T, which says, quote, "The final plat of the cluster development and reserved property, including all required restrictive covenant deed restrictions and homeowners association documents, if applicable, shall note and convey that the acreage reserved for agricultural open space is restricted to its noted use." So that seems to confirm to me, sir,
But
that
the next sentence.
W,
No,
No,
the next
T.
sentence of that paragraph.
This covenant shall terminate at such time as the property is annexed into the city and approved. But that doesn't speak to the conservation easement. The conservation easement goes with the land, no
And
matter
that's,
what.
that's a legal thing I was not
And
familiar
that's-
with, but
that's the
I
way
read it.
Cam shared when we met, that's the way Cam interpreted that, and that's why he recommended drafting the separate ordinance.
separate order.
To kind of overlay, our desire is that if someone elects to go down the path of a rural cluster subdivision, that the preserve acreage does just that. It's preserved and it is
perpetuity.
conserved forever, regardless if it's annexed, regardless of that status.
Okay. There's one other thing section P, as long as I'm standing up here. I raised concern, and I appreciate all the work you all did, because I told you in my letter that if both parties are not happy, it's a good settlement. But section P, my concern there was the water. If you have a water line that is sufficient, this requires the developer to build or to put in a hydrant. If you don't have a water line that's sufficient, what I see is the council is going to get a bill later on through Public Works to put a water line in, and then you're paying for it, not the developer.
So that won't happen, in my understanding, because that guy over there that's the fire chief and that guy that's the planning and zoning director, executive director, when this plan is developed and presented, one of the first questions is, well, will the water line support the development there? And that's through the technical review stage. And if it does not meet those standards, that won't go forward. So,
but the standard is in the legislation.
But the developer would have to, like, if they have a 4-inch line and they need a 6-inch line, and the 6-inch line is a mile away, then that developer has to pay to upscale that line.
I was just concerned that the county was going to get stuck with the bill, and the fire department wasn't going to have a hydrant.
No, and I appreciate
So thank you very much.
Yes, sir.
That was one of my questions too, Judge, so they would have to bring the appropriate size water line to that development.
Holden, you want to make any comment to that? Or John?
I'd rather allow the community to
All right.
speak.
All right. And respect that as well. John, you got anything to add, or did I hit it hard enough?
Right, that's the only question I would have, it just says where appropriate. So if there's not appropriate, could they still get that? I'm not gonna sign off on it.
Yeah.
Would that still be an option for them to continue on with that development?
I guess we'll talk.
Because cluster developments require it to go through the rezone process first, that requires sign off by planning commission, that requires sign off by you, that requires sign off by you guys. The answer is no. Where appropriate is wherever there's a level of development that would necessitate that fire hydrant. If he's asking for it, he's going to get it.
You don't have to say anything else? No. Anyone else like to make comment?
I do. I have a question. I've kind of been reading on there, and I just clarification just to, so the location of the septic system in the reserve area, it's the developer shall increase the acreage of the reserve area. It's 1/1, right?
So
1 acre to 1 acre,
If they have to
right?
go out into the preserve.
Right.
And they use 1 acre.
Right,
Then
but
the
then-
preserve gets bigger by an acre.
Right, because then the cluster lose an acre because they have to give the 1-to-1. So my question is, if you have your cluster and your tract, and you have 5 acres that has to go on the reserve that has to be used for the sewer system, the cluster then has to lose 5 acres because they have to give those 5 acres to the reserve. So then the reserve now becomes the cluster now becomes the reserve. So we keep saying that the sewage is on the reserve when actually the sewage is actually part of the cluster. It's just, it's the way it's worded, I just been thinking, do you see what I'm saying? Because it's 1/1. And we keep saying it's on the preserve when it's really no longer preserved because they took that and then the cluster gave to the preserve. So why do we keep calling it the reserve?
The parcels are going to have, like, if I buy a parcel or you buy a parcel, that parcel is going to be under your name.
Right.
But if you're septic, if you have to have an easement because of for whatever circumstance, you have to have an easement, or the community or the subdivision has a system that is a common system, and they have to have an easement. Then when that system, if it takes up 2 acres on the preserve has to be 2 acres larger.
Right, and that means you had to take away from the cluster.
But it's still on the, it's
Why would
still on the cluster, it's not on the cluster parcel because it's only there on the preserve by easement. I don't know how else. I mean,
but I'm just thinking because if they have to have the plan ahead of time and they know that the sewer is going to go onto the reserve, why can't they just say, well, that reserve now, those areas, the reserves become the cluster, and because you're going to give up areas of the cluster to go to the reserve. I'm just saying it's all part of the plan. It was just something I was thinking of. It was just kind of, I'm just questioning it. I just kind of.
That's the best I can explain it.
It's just kind of, I don't understand. It's 1 acre per 1 acre, and you're doing it before all the planning because you have to have all the sewer, everything in place. It's just you're taking away from here, but you're getting up here. You just
and
call it like that.
so much of it will depend upon the topography of the
Yes.
of the parcels and does it perk and
Right,
and
but you still
all
have,
those
you're
things.
still given that land. You take an acre and you take an acre. That's why I'm just saying.
Anyone else?
In other words.
Come on up, Keith.
If you give up the easement, it's still going into the farmland. That farmer is still losing acreage.
But your preserve gets bigger. Your preserve, if it goes in 1 acre, the preserve is increased by an acre.
But who takes care of that piece of property? Go ahead, Holden.
So going back to the beginning of this process, the idea of locating the septic system on the preserve acreage was meant to allow the flexibility for small lot development, while at the same time allowing, number one, the open space gets bigger. Where the preserve does twofold. It does the agricultural necessity, which is the primary, but it also does create open space. But the second half of this, early on in the conversation, was that If you wanted to grow sod, or if you wanted some sort of, if you wanted to graze on it, that would be okay. We've now considered with the separate ordinance to fence it or hedge it. But ultimately, what we're still ending up with is if it was 5 acres, you go from a preserve that would be a minimum of 25 into a preserve that's a minimum of 30. And that's still held underneath contiguous ownership. And so that's, this question of, well, who's taking care of it? If you're utilizing the preserve acreage for septic easements, we require there to be a maintenance agreement. We require there to be the bonding that we're working on tonight. So there is the underlying maintenance of the septic infrastructure that's associated with the homeowners association.
And we didn't want that to be on the prospective farmer or whoever is in control of the preserve acreage. So we were trying to help there, and that was, Kelly, that was a concern that you had.
No, that's been one of my concerns since we talked about
Thank you,
the
Holden.
septic not being on the property. And we're going to get into it and look at this bonding issue, but and I think that helps. My concern's always been HOAs come and go and they fight, and money goes away, and then you may have a farmer that's got a crop there that now they've got to dig up to get to the septic, and so yeah, I think that we've addressed this now, and hopefully this is going to work.
And the whole thing was to try to protect both parties.
Right.
And such. Any other comments? Roy Cornett, come on up.
I think of 2 examples. Ironworks Estates, been there 50 years. All those septic systems are on their sites, and some of them down as low as an acre. Septic system on the site, and there's enough room for repair area as well, which is part of the wet coat process. And so, back when we first started Ironworks, it was all 1 acre, and then we started the final section, and Dr. Offutt said, "Oh, wait a minute, we need at least 1 acre and 3/4 because of septic system." Well, I had to go out there and stake it out and show them, yes, you can build a house and have the primary system and the repair area on 1 acre with good soil. Now, somebody mentioned soil questions. All right, assume the soil is a question. Go out to Coal Ridge. Coal Ridge is, every house got a septic tank on it, and their effluent goes into a central lagoon down there that's fenced around by the track. So there's 2 examples which worked and been there for years. So.
I spoke last time, and my major concern was septic systems. From the beginning, why they went from 1 acre to 5 was there was not enough room for repairs. Septic systems were failing. And I talked to you all about the subdivisions. He said 50 years they're starting to start failing. That is good soil, but you go different places and you got to have room for repair. 2 acres is not room enough for repair. You can't dig up a system. If you dig up ground, it's like a cemetery. When you put a system in, that should be treated like sacred, like a cemetery. You can't put a pool on it. You can't drive on it. You can't till on it. Rita Jones said the other day you could do anything. You cannot do that on it. It's your septic. It's like the foundation of your house.
And that's what we put in the guardrail in the separate ordinance to try to
a person
respect that.
A person in Stamping Ground had 28 acres, and the health department told them they had nowhere on that 28 acres to put anything, any septic system but a lagoon. The woman didn't want a lagoon. Lagoons are nasty. You go different places, you have to have lagoons. And we got an engineer and put in a wetland system, but they didn't like it because we challenged them. Nobody likes to be challenged. They want it their way, or if you don't agree with them. But this is a serious problem. Another serious problem is the water. What if we get like Casey County? What do y'all keep wanting to grow Scott County anymore? It's big enough now. I couldn't get here on time for the traffic. How big? How many schools? And everybody says it don't affect the schools, it don't affect the roads, it don't affect the water, it don't affect the sewer. You're going to find out. You keep growing us, you're going to find out. That's all I have to say.
Let me ask you, Ms. McDowell.
Yes.
How would you, if you had a magic wand, What would be your
I'd
answer?
shut her down. That's what I'd do. I'd
What
slow
about-
I'd slow things down.
In all due respect, what about people's?
We need
private
affordable
property?
living housing in Scott County. That's what we need, affordable.
If you
I've
have
been
less-
told there's somebody that's donated a big farm for affordable housing.
If you have less inventory, your supply and demand, your cost just keeps going up.
But, you know,
And-
they just they was talking about the fire
And I
hydrants.
please know, I respect your concerns, and we have tried.
I want to say another thing. They were talking about fire hydrants. And we've got a subdivision coming next to us, right next door to our farm. It's going to affect our whole farm. And they let a pond be the fire hydrant because they didn't have a big enough main. And now they're selling that. I mean, the planning and zoning needs to be able to do their job and do it
Along to
right.
that same thing, that practice is used in quite a few places, and then there were things that were, and John, you can help me speak to it, but.
I've heard
we
it's
had-
not been a good thing. Come on up, Joe.
You know, there's requirements that they had to meet.
I know there is. I
And
know
you-
that.
It basically, it's called a dry fire hydrant system.
And I'm sure you've been out there.
Yes, and basically, they had to get a company to come in.
Put it in.
They had to, first they had to make sure that it was deep enough. They had to calculate how much water.
Right.
That's where engineers get involved, and they had to have it professionally installed. It couldn't be just somebody come in and stick a pipe in the pond. And they've got it concreted, there's a connection point, and they were required to put an access road that they had to include in on the deed of the property. That road is basically a gravel road. We didn't make them pave it, but it had to be an
That would
accessible
support,
road.
that would support a
and
fire apparatus.
That's, there you go, a
correct.
big truck, a
Yes.
fire truck.
Yes.
The
But-
rock they put down, my husband puts down rock every day. The rock they put down, you put it in there in wet weather or snow, who's gonna plow that and keep it plowed in the snow to keep it where it's open for the fire trucks? Whose job is that? There's so many loose ends. I'm not trying to be nasty or complain, but it's the way Scott County's growing, things are gonna have to be done and done with respect to people that's already been here their whole life. That's my main point.
But how do you tell your neighbor, you can't sell your land?
No, I don't want to tell them they can't sell their land, but there needs to be restrictions. And if we don't have water for them,
If where they want to build a supposed cluster subdivision, if the water
I'm not
is
trying to tell them what they can do.
If the water line does not support a fire hydrant, or if it does not support usage, then it won't get past the technical review. And that's, we have to depend on our technical review to help navigate. I appreciate you and respect you. I'll go back and say this, and I've shared this.
You know, I think the 40 acres, you need to really think the reserve of 40 acres. I think you all need to think this out.
I'll tell you what.
And I wanted to say one more other thing. You
Yes,
said there
ma'am.
hadn't been but 500 5-acre lots since from 2002 to
I'm getting ready to share this with you.
2026. You know why? There's no land. We're running out of land.
Let me share something. Like, a lot of people like to talk about this perception that we're running out of land. But the data and facts don't support that there's a tsunami of land loss. There's really not. And I'm going to read it to you. You can take it. You can do what you want to with it. Are we growing? Yes.
Too fast.
But are we?
How many
are we
schools
have-
can we pay for?
Pardon?
How many schools? How's our tax going to have to pay?
I can't. I'm not.
You build 62
I'm not,
homes and they say it's not going to affect the school. That's enough for 3 third grades.
I'm not in charge of
Three
the
first grades.
schools.
We need to think about this, people. I'm telling you, we need to think about it.
But going back to facts and data. So in 2010, there were 7,310 acres of 5-acre tract lands. And this is what got this whole conversation started. In 2026, Whitley from Planning and Zoning, she updated the data. In 2026, right now, what she shared with me was 9,438 acres in 5-acre tracts. So that's 2,128 acres over those 16 years. 2,000 and, 2,100. So you all know, and there's next to no agriculture going on that 2,100 acres. Would you agree with that, Philip Howard? I mean, there's none. So what we're trying to do is seeing if we can balance this. So I'll pledge, I'm going to send an email to Holden after this meeting, and I will ask Holden to schedule at our July meeting in July, the end of July next year, that we come right back here and we look and see how many cluster subdivision applications have taken place, how many subdivision applications, if there's any that are in process, in development, and we'll talk again and use facts and data to kind of keep a saddle on this. And then try to do that annually as we go forward. And if we have to tweak something, if we learn something that we need to change, then let's do that. But we have spent a lot of time and we have put in a lot of guardrails to try to bring balance. Now, back to the big picture with what Whitley has shared with me. In the A1 zone in 2010, what I believe was shared with me was 163,860 acres. In the A1 zone in 2026, Whitley's sharing with me that it's 160,581. It's a 2% difference in A1. 2% in that 16 years. So I don't disagree that we are growing, and we have to be aware of what's going on. We have to try to put in some things that try to provide balance. This rural cluster subdivision proposal, maybe it will help slow down those 5-acre tracts being carved off, and then provide a little bit of more housing. We'll come back in a year in July and we'll revisit where we're at, and we'll continue to do that on an annual basis. If we need to tweak it, then we'll tweak it. We're putting money into PDR that we've never done. We had these stakeholder meetings, and I shouldn't say never done, we hadn't done for a few years. We've had these stakeholder meetings trying to address this, and there's other things that we can do, but it's how do you eat an elephant? One bite at a time.
One bite at a time. Let me add into what you just put in. This comes out of the Kentucky Department of Ag. From 17 to 22, we lost 8% of our farmland. Active farmland.
Where?
Farms. We lost 12% of the active farmland. There is a big, if you draw a line across Delaplane Road, all the way across,
Rogers Gap,
all the way across, back and forth, the quality of land that's farmable is south. I don't give a hoot, to be perfectly honest, from a personal point, what they do north. Because those hillsides, you can put houses on, but you can't farm it. You talk about stuff not perking, you can't hardly keep a marble on top of the hill down there, much less anything else, or try to grow something with rock about that deep. And that's where we're coming from. We want to keep the farmable farmland protected. We're not after all of farmland in Scott County. Most of that don't qualify. But we need to slow down the farmable land. Otherwise, where are we going to eat? That's my question.
Can I ask a question?
David Livingston.
So I'm not a farmer.
Right.
And I'm also not a contractor.
Right.
So I don't have the knowledge of either one of those. But, so speaking from that angle, my question is, we're talking about a cluster development. I'm sure everybody's aware of Publix and Target. Okay, that's a lot bigger than a cluster development.
I agree.
And so I've not seen anybody really arguing about retail or heard anybody arguing about retail, which is a lot more damaging to farmland. You know, I live over in Bradford Place.
You live right behind me. I'm your neighbor.
When I started in Georgetown College, that was all farmland.
Exactly.
You know, I think this aspect of doing this possibly slows down the risk of growth that we're running into, because what would have been developed as a Bradford Place or Rocky Creek or something like that, when you're living on a third of an acre and having 900 homes, I think it is, in our neighborhood in Bradford Place.
Yeah, uh-huh.
You go into a cluster development and then preserving the acreage as well. So instead of that massive development of plastic houses, you end up with smaller development with preserved acreage. And that's how I see it as a novice at any of this that we're talking about. So I don't know if that's right or wrong, but that's how I see it. And to me, that's a positive. Because the other thing is too, when I pull out of my subdivision on Hemingway,
go out the front
onto the bypass, and I look across the road, it reminds me of Richmond Road at New Circle. And I think about, what is that going to look like 25 years from now? Because everybody knows, until somebody bought those apartments on Richmond Road and rehabbed them about 7 years ago, you did not want to be in that place.
And the other thing is, in 95, from 95 to 2004, when I came back here, I was in Jessamine County and was talking to their fiscal court. And that's when they had their explosions. My wife had to go to a doctor now ever since April, once a week. I don't recognize it. And there is now one farm, if you're going down Nicholasville Road, that separates Fayette County and Jessamine County.
There's a new Kroger and Lowe's going on that farm.
Well, no, that's the other.
Right.
Go right before Brandon, right on the county line. The one on the right-hand side going down is being developed. The one on the left-hand side is still green, but belongs to a banker. So how long is that going to happen? And we don't want Scott County to look like that either.
And we are trying to address the 5-acre issue and bring a little balance, and we'll come back in July of 27.
But it's my question, which is better, 900 homes or a cluster subdivision?
Now, I'm not going to speak on the back end for them right now, but I would like to see every 5 years we're looking at the urban service boundary. Let us keep the businesses close to that boundary as we expand.
Now, that's a city hall.
I know that's a city call.
Yeah.
But I think we get a few of those dollars too, right? From property taxes and everything.
Keith, the property tax revenue that we get from the county is it is a very small portion that
to the other. I know that. We're aware of that.
And you know, I'm not making decisions based on how much property tax, because like our property tax for the county is in the bottom 5 in the state, and you know. We exist to provide services, and we have to have funds to do that. And we're blessed that we have a lot of industry and such. But the property tax is not a decision maker for me, and I can't speak for the court. But we've never talked about, well, we can't do this because of property tax, and we have consistently lowered our rate because of the reality of the assessment continues to go up because of the values. And I'll go back to supply and demand. If you have less supply, your costs are going to go up. And you know, let's come back. Let's consider this and take it forward. And then you know, I pledge that we will come back in July 27 and let's look at what we have, and if we need to tweak.
I think Rob said last time I was in here, the 5 acres is what we've got to get rid of somehow, and get rid of it in a conservative or a productive way.
So we're hoping that this will positively impact that.
And I'd like to ask something just as a farming standpoint, something you all said before, and just out of curiosity. say, maybe we should up to 5 acres. But I think you guys said like the minimum farmable land is 40 acres.
A good,
So I mean, if you moved it up to 10 or 15 or 20, and you guys are thinking like 40 would be what you would want minimum?
to make any money livable income, you need at least 40. And I would say more than that. If you're doing, in a compact area, doing vegetables or something of that nature,
No, I think you're talking about minimum lot size to build a house on.
Well, I'm just
Is
talking
that
about
what you're
minimum build, you're right. A
Yeah,
minimum
well-
size of lot, like Fayette County's 40 acres.
40 acres,
Which
Woodford
makes
County,
it
the same thing, I think.
Really unaffordable for a lot of hobby farmers that would like to have a couple of cows or horses
Yeah.
like my wife or whatever. When you get into 40 acres, it's
It's a big mess.
it's bigger than what a lot of people can afford.
Not, we talked about that in these stakeholder meetings, didn't we, Rob and Rick? Y'all were in those. Not one person said, yeah, let's raise that without compensating people for, the loss of their potential. It's just.
Payoff. I'm not arguing
Yeah.
that.
So,
So-
Judge,
Rick Costello.
if you don't mind,
No.
I'm going to share a real-life story that's going on in this county right now. Everybody's talking about you can't, you got to, and I understand the need for room. So I've got a good friend of mine. He lives on 16.9 acres, but let's call it 17. There's actually 2 small homes on it. His dad bought the property close to 50 years ago, okay? It's not far from this courthouse. And of that 17 acres, there's about 3 acres. Really, it's probably closer to 4, but I'm going to use 3 acres that's got the 2 homes, a big barn, and the lots, and the yard, front yard and backyard for both of the homes is about 3 acres. So that brings it down to 14, right? So he currently, and has for a number of years, has 15 cows. He rents or borrows a bull. He has no creek and no pond. And he raises 15 cows with 15 calves every year. That's 30 head. And he's operating on 13 acres. Now, he supplements with hay year-round. But in the midsummer months, as long as there's rain, he doesn't have to use much hay. He actually has his property lotted off, so he rotates. And he has 2 of the rotating lots that he gets a first cutting of hay off of every year. There's a lot going on 14 acres. So I chatted with him recently to kind of get an update. And so he's waiting on, he's got 3 calves yet. He plans it so that he doesn't have any winter calves. You want to deal with the weather and all that. So he's still got 3 cows left to calf, but he'll soon have 30 head in the next couple of weeks on 14 acres. Been going on for a decade. And he's worked out deals with people that have 5-acre tracts that don't even have anything on it but grass hay. So he mows them twice a year. But I mean, he works all that out, and he's done really well. So today, at today's prices, and so I used to run cattle, I don't anymore. But I'm pretty sure that the stockyards have, right now, a 600-pound calf, which he'll have 15 of them in several months. He just gotten rid of the previous 15 from last year. So about a 600-pound calf at $4 a pound. I'm pretty sure that's accurate. $2,400.
We bought 600
times
pound calves for
15
$29 today.
times 15 is $36,000 a year on 14 acres. That's happening right now in this county. I'm just using it as an example. This guy's pretty sharp. He's a younger fella, pretty sharp. I wouldn't do it, but I don't have it. I just didn't have.
But your comment is that there can be some production on a smaller acreage.
So now I want to attach that. You're correct.
Yeah.
That's my comment. It's happening, okay? But back to preserving the land. Right now, we're preserving none. Nobody's using. the current ordinance as it stands. I think it was Winding Oaks.
There's 9,438 acres in 5-acre lots.
Yeah, but I mean.
And that's what you're saying, that nobody's using
Nobody's
ag,
got any reserve.
like nobody's using
There's no
anything.
reserve either.
Or very little. We should say there's very little ag going on in those 5-acre lots.
Probably not. But now this guy's made deals with some folks.
Yeah.
He's even made deals with some folks that got 5-acre lots, they got a house, but the other half is growing hay for him. So anyhow, he's, pretty energetic and pretty entrepreneurial, I would say. But my other point is the current ordinance, nobody's using it. So we're gaining zero. This ordinance, we don't have guaranteed anybody's going to use it either. I don't know.
We can come back here in July and he say zero.
My point is this: I want to see the land preserved. The other side of it is the PDR program. Most people in this room know how I feel about that because of the money that's involved to purchase the development rights. I've done the math because Scott County has PDR. I think it's 660 acres. I believe.
And we've committed $500,000 to current applications in our budget.
That's 660 acres, and I'm using round figures, okay? Not, it's a round figure, but it's pretty accurate. The last PDR that was done was in my first year on this court, which was in
How many years ago was that?
2015.
2015.
2015. It was a leftover project from the previous court that hadn't made it through the federal government, and all that has to happen, right? But it did, and it came to us, and I don't know how many people were here when that was voted on. I voted no. As much as I want to preserve land, because I did the math, and it's 660 acres, I think it was, the county directly put in $1,100,000 of our tax dollars to purchase those development rights. Indirectly, at the federal level, the same amount was put in to PDR. I think I'm right on those numbers. So now every time you want to do 600 acres, it's $1 million. That was in 2015.
But it would be a different story now.
Well, but those are direct tax dollars from our half of it is direct from Scott County taxpayers. Back then, I voted to set this money aside. I'm open to considering it, right? If somehow the federal government says, okay, let's go down a path together, I'll still consider it, but I'm going to look at the numbers.
Yeah.
So that's all I got.
I think the big point you wanted to make was there can be some production on smaller acreage, and this gives us a possibility. Amanda Hall would like to make a comment.
My name's Amanda Hall. I am, I guess like a 4th-generation farmer. So anyways, I do want to say when you all are making decisions off of the recommended acreage per head is we run a lot of feeder steers, and they always recommend just a ½ acre per animal when it comes to running all grass cattle, because then you're dealing with mud, you're dealing with erosion issues, runoff, all those sorts of things. But anyway, so where our farm is located, we are over by Interstate 64. So we're in the little Lexington corridor where nobody really wants to claim us, but we are Scott County. So back in 2017, it was actually my FFA SAE project. My husband and I, we purchased that farm for $7,000 an acre. And then back in 2022, we purchased our neighbor's farm for $22,000 an acre. Look at the difference in price right there. But you mentioned Winding Oaks. We actually, somebody did? Winding Oaks? It's over there on Cane Run? Yep. So we actually rent the green space behind Winding Oaks, and it's about 25 acres, and we're able to run whether our bulls on it throughout the winter time as a nice safe place for them. Right now we have our weaned calves from last year's fall calf crop that are on there, and that's actually working really well for us. I mean, would I love to see all the farmland preserved? Yes, but also as a business owner too, we're using our capital off of our land value. I'm in a middle ground, standing in the middle where I love seeing, our land appreciate, but I also want to protect it. But I also believe that everybody has the right to do with their farm is what they want. But what I think that you all are trying to do, I really appreciate it because you're trying to work together. That green space that we can have the cluster developments, like for instance, if you have a 100-acre block of land, you can do 20 1-acre tracts as opposed to, the 5-acre tracts. So then you can do the 80 acres. The farmer is able to move all their basis points back over to the 80 acres to where they're still able to capitalize on the front 20 acres, get the money, their retirement, their stuff that they've worked their legacy for their family, but they can also save on the tax dollars and have farmable land in the back. I think there's a way where we can work together and we can make Scott County still have that rural feel by welcoming still people in, because the 5-acre tracts, it is what it is. It's a lot of finish mowing. You can cut hay, but for the majority of farmers, it's a pain in the rear. You're moving equipment up and down the road. That's a hazard for people. The sheriff's department doesn't want to deal with it. We pissed off, sorry for the language, everybody on Leestown Road earlier moving a planter, and it's just getting dangerous. So the more that we can try to consolidate those areas and maybe work in those cluster developments or encourage those, I think it's a great way too for farmers to go about. I think that we've just been so streamlined in how we do land deals that we're not able to kind of look outside of the box and how you can save when it comes to capital gains or your taxes. And I think if we're able to educate farmers, work with you guys, I think that we can find a really good middle ground to make everybody happy.
I don't know if we'll ever do that, Amanda, but we'll try to find a middle ground.
I think there's a good middle ground because...
No, I think, I agree with you there. I was just being
I know, and I
lighthearted.
struggle so hard because I always keep my mouth shut on Facebook, and I always see people saying, farmers can't make any money, they need to sell so they can make... I'm just kind of like, when did it become okay to start bashing on farmers? We're doing as much as we can, as best as we can, so I think we can work together a little bit.
Appreciate your comments.
Yeah.
If there's no other comments, well, we've got Roger Quarles.
Thank you, sir.
Yes, sir.
I don't want to repeat what we've said before in other meetings, so I'll try to skip a little bit. I would mention that the judge responded with a letter to one we'd sent him, or email type letter, and it was very eloquent. There's no other way to describe it. If you haven't looked at it, you should take it. I was telling him how eloquent he is.
Well, I wanted to respond to you all because I know this matters to you all, and you all put a lot of time and thought into it, Roger. And,
okay.
And your letter, your email to us deserved a response, and just like everybody,
I appreciate that. Is this working?
And this was the Soil Conservation District letter.
Is this working for you now? Okay, well, anyway, he depends upon quite a bit of reference to USDA about 25 acres or less. And I listened to Mr. Hostetler's example there, and as well as that is, that won't even support one person's salary. Even all he's doing, it won't support one person's salary. Not even the farm wages, it won't support that. I promise you that. Our farm wages are $35,000 to $50,000 per person, and it won't do it. You can't assign somebody that task and have any money left over. Doesn't mean to say they can't do something on the 25 acres, but to say that you can use those things for all these things you mentioned, leasing arrangements, specialty crop production, livestock grazing, hay production, community support, ag, so forth, that is not the history of Scott County. It's not. We don't have people doing that. The only one I could think about offhand was Miss Honorcamp out maybe on Robinson Lane. But we don't have people operating those things on small acres. Now, what we asked for, and I think that the cluster thing is coming. I think you're going to go forward with that. So now I think we're down to tweaking maybe a little bit some language that would help. And what we've asked in the past is to keep the preserve area in one track instead of dividing it up in 25-acre increments. Now, the way I understand it, if it's a 98-acre, or if it's a 50-acre parcel, it'll be a 25-acre set-aside. If it's a 98-acre parcel, it'll be not two 25s, but it would be the difference. Is that right? Okay, so But if it goes over 100 acres, then that allows the developer to start carving it up into 25-acre lots, or at least 2 anyway. And that's what we don't like.
But all of it would have to be under a conservation easement.
But we want it in one continuous tract, so whoever owns that land or leases it out, that one farmer can tend that entire contiguous tract and not 2 25-acre tracts. That's what we think is a good idea on that.
I have a question about that. Why? What's wrong with 2 25-acre tracts?
Because they're essentially not a very efficient farming operation. Just as she mentioned about moving the equipment, if you go to mow hay, first thing you do, you may have to spray it once, then you go in with your mower, then you go in with your tedder, then you go in with a hay rake, then you go into your baler, then you take other tractors to move the hay off the fields. That's about 7 trips that you've got to make in and out of that tract. And if you've got a larger tract, if it's available, that's, you only have to do that, all those trips once.
But they're they have to be connected.
Well, but it may not be under the same ownership. If they're 2 25 acres, it may not be under the same ownership.
They'd have to be the same plat, right? You couldn't have 2 different owners.
Sure you can. The way they've allowed this in the past is 2 25s, right?
25 acres, that's
But, right, hold right, it would just be the same owner.
Let's talk about, if we're putting a conservation easement on it, like we're trying our darndest to help.
I got it, but
we're
make
trying,
one.
like, we can't pick this apart.
Well, we're just suggesting that everybody's better off if it's one continuous tract of preserved acres, even if it's over the 100 acres, original cluster. We're just saying, let's keep that in one tract instead of dividing it up. And when I read that through your, shifting to your proposed ordinance now to take care of some of these things, I was looking at page 5, number 4, about middle ways of the page. It says the owner of the preserved acreage, homeowner association, or other designated entity shall be responsible for maintaining the required fencing and so forth in good repair. Now, why would the owner of that preserved acreage be burdened with that requirement? Why would they do that? A guy comes in and buys it to farm. Why are you going to make him responsible for building a fence around that and taking care of it?
What page are you on, Roger?
Page 5, about middle ways of the page, where it says fencing of septic system areas.
I've got the wrong page 5.
It says right there, the owner of preserved acreage. And we're assuming that some farmer type person is going to buy the preserved acreage in order to do farming on it. So now you're going to make him responsible for fencing that and burdening him with that? And I'd also ask you, who's going to pay the taxes on that septic field? No, they're saying the entire septic area, I believe is what I read here.
What we were trying to do.
I think that's a good question, though, right? Because they can't sell it.
No, they've bought it. Whoever buys whoever buys the preserved acres is going to inherit this set-aside septic field.
But Colton, can somebody buy the 50 acres? Or does the HOA just own it and a farmer could rent it?
Here's how it works, Ryan. If they set this cluster development up and it has to run, the septic has to go on to the preserve, then there's going to be there's going to be a plan that shows that. But there'll have to be an easement that when that person buys that 50 acres, they know there's an easement on that land for that septic. Yes, it has to be that way. And I hear what Roger's saying about the fence.
But the fence should already be there if it's already been developed.
The fence, we should make the fence be put up as part of the development. And
we asked for that several times.
And there's loopholes in the fence, and people don't know where it needs to be and what it needs. Everything needs to be ironed out.
If I may,
and we can change this one right now. If it's the pleasure of the court. It's not Joe Pat. It's the pleasure of the court.
I believe the confusion comes in specifically for the fencing, because it says the owner of the preserved acreage, homeowners homeowners association or the designated entity shall be responsible for maintaining required fencing or other barrier. And so it creates this option that it could be the owner of the preserve tract, it could be the homeowners association, it could be some other unnamed third party. I think what Mr. Quarles is saying is it doesn't ever need to be the owner of the preserve acreage, because it is the homeowners association, it's the original platter who has proposed to encumber that land, and so it should be their responsibility.
Right.
That seems very reasonable. For repairs and everything.
So Ben Willis,
Sir.
help us fix this, because we can fix.
Yeah.
We can't change the other two, but this is ours.
Okay.
And we can change this one to, if it's the pleasure of the court.
Okay, so what I'm thinking is going to happen is, say there's as little as 25 acres preserved, but there's going to be maybe 2 acres or something of a septic field or something like that, maybe 3 acres, whatever it is, it's going to have a fence around it. That's what the ordinance says now, right? And so we're going to debate on who's going to take care of it. But what I'm saying is that who's going to pay the taxes on that area? It's got to be a fair cash value. Mr. Burke over here will put at least $5,000 on that, because I've sat with him and he explained
Whoever
it.
owns the preserve.
So why does the farmer have to pay the fair cash value for a septic field?
Like I can't just if ifs and buts were candies and nuts, we'd all have a Merry Christmas. I say that all the time. I can't pick that apart like that. And I mean, it's just like you can't see the forest for the trees. We are trying to move this forward.
I'm not objecting to your cluster
If you buy that
idea.
land and it's got an easement, and you know what you're getting into, then that land is ag land, and you're paying whatever John Burke assesses it at.
Okay, but he puts fair cash value on fenced off lots. He doesn't use ag value.
That's not a fenced off lot. It is part of the preserve, and it is. It's not
Part
like
of the overall acreage, you just happen to have a fence around it.
right, because it's got an easement on it.
Yeah, but once he sees a fence around it, it's $5,000 minimum.
But you can always appeal that, and
that's
completely.
I know it, and he'll quote you state law that tells him what to do. But at any rate,
Sounds like you've had an experience.
I learned something. We had two spots back there. One of them's got a garden on it, and one I cut a little hay off of. They're 1 acre each, and there was a fence around it. And he said, "Well, that's a paddock. It's $5,000 minimum." And I'm like, "Why?" So anyway, he says that's what he does when he sees fences around things. He puts $5,000 cash value on it. So anyway. Talking about the fence for a moment, if we may. We've already got, there is no description of the fence in this ordinance. Okay, but we've already got 2 instances in planning and zoning ordinances that describe fence. I think we ought to go back and use one of those examples to describe the fence that you should put up. Is there a problem with doing that? You either use the landscape ordinance or go back to what I call the John Lacey fence, where they put it somewhere else. But nonetheless, please, in the ordinance, describe what kind of fence it has to be, so we don't quibble about this forever, if you will.
Can I say something back here? They talk about big fence in Painesville. I'm from originally Painesville, and you all were all my people farming. And the big fence is chain link fence. It's been there for years. I think that what they need to go to make it where it's not a problem, chain link fence. Good as anything, it looks good, it holds up. I think that's something that needs to be considered.
Okay, then just one last comment here about where we asked for a 40-acre minimum on clusters, is that we've had several meetings, as you described, one here, this is the second one. We had a public library meeting, we had some stakeholder meetings. I never heard one person object to the 40 acres of the amount of land that should be put off in one spot. Not one public comment have I heard to object to that. So I'd still go back and say, if you're going to use the 25 acres minimum, at least put the balance of the preserved acres in one tract, so that it might grow more than that. Unless there'd be some questions, I'll leave you alone.
Any questions or comments? Thank you, sir.
I would ask one other thing. I don't know who is advising planning and zoning on agricultural issues. But, you know, when I come before you, I don't offer wiring diagrams to the electricians. I don't go to the banks and tell them how to do business. I don't write any briefs. I've paid for a few of them, but I don't do that. I don't advise other people how to do your business. But I would like for planning and zoning to have a designated agricultural policy person. And I would hope maybe you should think about the Soil Conservation Board, because we are elected officials. Certainly not at your level, but we are on the ballot occasionally. And I think those of us on it, with the exception of one, are full-time farmers. We don't have any other jobs to do except this is a somewhat volunteer basis. But we'd ask that planning and zoning have somebody that they can call on agricultural issues, because I don't think any of their folks sit in that seat for us. I do know that the developers sometimes have warm seats over there, but we don't. And we'd like to have a warm seat over there occasionally if they have developed any type of agricultural policy.
Would I disagree with you that it would be productive for planning and zoning to have a resource for ag policy? No. I agree with you. That's not bad at all. But I want to defend our staff there. Like, Holden hit the ground, and I asked him to help me put together this stakeholder group, and he has worked tirelessly.
I'm not condemning him. I'm offering a suggestion where we'd feel more welcome.
Yeah, well,
Holden Fleming is excellent. I dealt with him, and he was brand new when I started dealing with him. Let me tell you something. He's a man of his word. He does his job. He's trying to do his job. And I've told him many a time, I hate to be in them shoes, because they're hard shoes right now, what we're going through and how we're growing. Holden, I appreciate you.
Thank you for that comment.
Now he's going to be
and
pushing
Roger,
for a
thank
raise.
you.
Oh, no.
All right. Last one.
Last one. Sorry. He stole some of my thunder. So one of the things I want to hit on is density. And we have increased density heavily. And that is one of the problems. If you're putting a cluster on Porter Road, you're putting a cluster on Lyle Road, you're putting a cluster on wherever else road where we don't have center lines down the road, you went from putting 20 houses on a 100-acre tract to putting 50 houses on a 100-acre tract on the same road. At 2 cars a house, that's 100 cars moving back and forth every day with big cedars, big planters, big horse trailers, whatever, that are in the way of those cars moving around. So our density has increased too much. We were coming on going up from 5 acres to something else. I remember years ago, we went from 1 acre to 5 acre, and the sky was going to fall, and the sky never fell. So people will cry about any change in acreage increasing. And the biggest hit is the divided reserve tract. We must not divide that reserve tract. Because what you're doing is you're mandating a business model for that farmer. You're mandating to say, here's your 25 acres, here's your 25 acres, here's your 25 acres, and they should have 75, or they should have 100. And it should be up to that person to say, I only need 10 of it, I'll lease out the other 90, but the 90 is intact, the 100 is intact, whatever it is, it's intact. And you don't have divided acreages. Once you put a house on a 25-acre tract, it turns into a mega house lot. It will be a, McMansion lot. And once you put that on there, you lose 2 acres to roads, 2 acres to pool, 2 acres to garage, whatever, fencing. So now you're down to 23, 20 acres, whatever. So, just because one person can do a darn good job on the acreage they have, doesn't mean that they're going to be producing food, fiber, and grain, which is what we call the effort for ag purposes, on those acreages. And we do not have the ag production that's going to happen on 5 acres, 10 acres, or 25 acres. And whether it's, it's just not going to happen. So, about the housing, nobody complains about housing, whatever. Oh, no, nobody complains about retail. You're right. Everyone wants a Long John's, they want a whatever, Hobby Lobby, and a Target. Oh, my God. But the thing about it is when people see area pulled into the USB, they don't argue because it's a done deal. They just don't argue it. It's a done deal. And you have the ability to do high-density housing, and you have roads, but most importantly, you have sewers. So that's why people don't argue it. They just say, it's done, the creep of the city. But be careful about the densities we're putting out into the countryside, because it's not just houses, it's cars, it's big pieces of equipment, it's all those things. And keep the reserve in one singular tract. And keep it reasonable, don't make it weird. That's it.
With that said, we will move forward here. I will ask Ben Willis to read the summary to 2604. Before he reads that, I will say that I've received no less than a dozen phone calls asking me when this will take effect, the accessory dwelling unit. And all of those phone calls were, hey, we think this will be a great thing to provide an option instead of having to buy 5 acres and put another house on. So I just speak to this as I think this is a positive tool in the toolbox.
Judge, can I make some comments for you?
Oh, absolutely.
So I've been racking my brain over all these numbers. She just stated if it's 100 acres, 50 acres gets preserved, then another 50 houses could go on there. The way I'm doing the math, it's not like that. And Holden, you might help me out on this. But our current regulations, 1 building credit for every 5 acres. You got 50 acres, that's 10 credits, right? Am I right, Holden? You got, under current regulations, you got 50 acres, 1 house every 5 acres, that's 10 houses, plus you preserve. So that's 11 houses, right? The new regs that we're going to vote on here in a minute, 1 house every 2 acres on that 50 acres, right? 25 acres, 50% gets into preserve, so it's 25 acres preserved. 1 house every 2 acres, so it's 12 houses, plus you 1 on your preserve, that's 13 houses. So we're talking about 2 more houses with this new ordinance. That's all you're getting, 2 more houses, but we're already losing 5 acres. So I don't see where we're saving any farmland by adopting this new policy.
But going back, Rob,
and I understand what you're saying
you
about
get
the 5 acre
zero preserve on the 5 acre tract.
That's right, but we're not addressing the fact that the problem is with the 5 acres. It's really not with this cluster thing. Our problem is with the 5 acre tracts, not the clusters.
Well, the cluster's not being.
A builder is only going to pick up 2 more lots with this new ordinance. They're going to pick up 2 more lots to be able to build on. I don't think that's going to be a big rush, which I'm glad you made. We'll come back to July. I don't think it's going to be a big rush for people to come in and start doing a cluster, and we're going to start saving all these 5 acre tracts. I don't see it happening. I don't think we're going to save any 5 acre tracts, and I don't think anybody's going to do the clusters.
I think though, if you start looking at it, when you start, and again, I'm not a builder or developer, but 5 acres is selling for $250,000 to $300,000 right now. I guarantee you'll be able to sell 2 acres for 125, 150, which is going to be a lot more profitable.
And I agree. And somebody said something about 1 acre lots. I'm all fine with that. But if we follow what this ordinance is reading, we're only picking up 2 more lots per cluster every 50 acres.
Commissioner Jones, if I may, that is why when we wrote this ordinance, we've tried to lower that lot size down. Because you're right, if the developer builds out the cluster site at 2 acres a pop, they're only going to pick up the 2. But if they build it at 1.5 acres or 1.25 acres, that's where they're going to see more lots.
It's not what the ordinance says. It says 1 credit for every 2 acres.
That's correct.
So if you got 25 acres, you're getting 12 lots. I don't care what size they are.
Yeah. So,
right?
One minor correction. The density is calculated on the initial parcel size. And so if the first parcel is 50 acres in total, it's going to be 25 total houses that you can get in there. And so that's where if you split it and you only do 2 acres, your math is right. But when you split it and you get down to 1 acre, that's when that number is going to go up.
So it didn't read that way in the ordinance.
I believe it's 1 dwelling unit per 2 acres.
For 2 acres.
Yeah.
But it didn't say it was covering the whole 50 acres.
Okay.
It's not what it said. Which I'm fine, but
Well, that makes a big difference, though.
It does. I mean, it needs to say that in the ordinance, because that does make a huge difference to a developer that would see that and say, hey, yeah, I can get 25 houses on that.
Yeah. And that has been the intent all along. And that is the number and the math that the Soil Conservation Board was working on and everybody else. What it comes down to, though, is the lot size for these clusters is really the determining factor on how many units you're going to get in.
So let me ask you this, so, because it says it can go down to a half acre.
Mm-hmm.
So if they go down to a half an acre, does the other acre or whatever become preserved land?
Yes.
So we could pick up some preserved land.
Yes.
If we can get the better lands to do the settings on. So
Yes,
that makes a
and
huge
in that
difference.
sense, if you go all the way down to half an acre lots for the totality of the cluster, you end up preserving about 76% of the
And I would
total
guarantee,
parcel.
if you got half acre lots out in the county, there's gonna be people buying pretty quick.
And that was what this sheet was about.
Yeah.
That you shared at previously meeting. So, any other
Yeah,
questions?
Yeah. So thank you, Howard.
Yeah.
No, I just think
Commissioner
it,
Jones, if I can preemptively answer a question that you brought up to me earlier.
Yeah, 412, section 412.
There's language in this ordinance that prohibits the preserve acreage, and so whether that's one parcel or multiple parcels in increments of 25, from utilizing a conditional use on the property. And so the expectation, again, is with this preserve acreage, it has a residential right and it has an agricultural open space right to it. Things that are not included, and that's, I think, what you really wanted to know. Conditional uses in the A1 zone are cemeteries, so you couldn't do cemeteries, public and private parks, commercial feedlot operations, slaughterhouses, airports, churches or libraries, home occupations, bed and breakfast, animal hospitals, kennels, secondary residences, commercial landscape operations, or distilled spirit storage. And so none of those uses would now be allowed on the preserve tract. It would just be residential or agricultural.
Any other questions or comments before I ask?
you can put residential on the preserve tract?
One unit.
One unit.
Oh, yeah, okay.
And then no secondary residences.
Yeah, I'm with you. Yes, the one unit.
1 unit plus accessory dwelling?
Yes. Meeting all other requirements.
So Ben, will you please read the summary for accessory dwelling units?
Happy to, sir. Scott County Fiscal Court Ordinance Number 26-04, an ordinance amending the Georgetown-Scott County zoning ordinance regarding accessory dwelling units. Summary. Number 1, pursuant to its powers under KRS 67.083 subsection K, adopts the recommendations of the Georgetown-Scott County Planning Commission following a public hearing on April 9, 2026, for amending the Georgetown-Scott County zoning ordinance regarding accessory dwelling units. Number 2, adds a definition of, quote, accessory dwelling unit, parenthetical ADU, end quote, and amends the definition of, quote, agricultural uses, period, end quote. Number 3, under, quote, specific use regulations, comma, end quote, adds a new section on, quote, accessory housing, end quote, which includes sections on purpose, applicability, general requirements, parenthetical, including certificate of occupancy, structure type, wastewater disposal, recording, sale, or transfer of accessory housing units, and density, end parenthetical, and additional standards, parentheses, including size, density, occupancy, and design, end parentheses, period. Number 4, provides that if any section, subsection, paragraph, sentence, clause, phrase, or a portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. Period. Number 5, grants the Planning Commission discretion to make non-substantive revisions as necessary to ensure internal consistency, clarity, and conformity with adopted formatting standards. Period. Number 6, provides that all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Period. Number 7, takes effect upon passage and publication. Period. The full text of this ordinance is available for examination at the office of the Scott Fiscal Court Clerk, 101 East Main Street, Georgetown, Kentucky, 40324.
Questions or comments? Would there be a motion? Motion from Kelly Corman.
Second. Second, I thought Chad was no second.
Second from Ryan Pratt. Oh, Chad Wallace with the second. We'll give Chad the second.
That's fine. Go for it, Chad.
Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed?
No.
Have one no. Motion passes. Number 15. Before we move forward, back to Roger's question. Ben?
Sir.
So I would propose to the court to amend Section 4 to reflect
I mean, either. I'll quit looking.
We want to amend it, he'll just read it.
well, we're going to change what he's going to read.
Okay.
I'd like it to reflect that it be a 5-foot no-climb fence with a top rail, top board. Would that?
6 foot. It was 6 foot.
Holden, can you confirm, is every one of them 6 foot or 5 foot? I'm sorry.
That's what was in the ordinance. I just went through this.
I'm going to defer to my senior planner, Ms. Elise Katz, on that. She's very familiar with that ordinance.
All right.
So I can direct quote of. So there's two source documents that you can kind of pull from. There's the A5 specific ones that are associated with the zone that you would have to go to.
And this is going to become A5.
Correct.
Let me jump in.
What? No.
Hang on. The cluster development does have specific language for it within the cluster ordinance. My request would be that the preserve ordinance that you're reading on just reflect the cluster development standard. There's
not change the language. Is that what you're saying?
No, we got to change it to reflect.
Okay.
Just change it to reflect exactly what is written in the cluster ordinance. And in the future, if the cluster gets changed, then that covers that as well. That would be my recommendation.
But we need to spell that out very clearly.
So are you saying refer to the cluster development in this ordinance?
That is exactly what
Instead
it is.
of writing the same language
Yes.
in each one?
Yes.
Where does this talk about, I'm reading right, where this one talks about fence?
So the ordinance that we're currently in the process of reading, this is the conservation easement ordinance. Section 4 discusses fencing of septic system areas located within preserve acreage. And then it says, the barriers, the fencing or other barriers shall be sufficient to reasonably prevent vehicular traffic over septic system components, livestock access to septic tanks, treatment units, and drain fields. What I believe the desire is to specifically require the fencing that's spoken of in the next ordinance, which is the cluster development ordinance.
So in L, in the cluster, in L, it says required landscape buffering and fencing. All cluster developments are required to meet relevant requirements of the adopted landscape and land use buffer ordinance. That's all we need to say?
Yes. Yeah. The one kind of consideration with the existing language is it does mention hedges or other, and this is in your conservation easement one. You would essentially be substituting hedges and other fencing for just that requirement, which is totally fine with staff.
So I think we can call that as amended
Would you,
and then fix the language.
Right there.
Yes.
What is it?
If you'll give me just a moment, with Ben's help.
That's the conservation easement. So that's not what it
We're changing section 4:05.
What number is it?
We're referencing section L of 2606.
But that's for septic.
Can we just say that,
That's not what they're reading right.
Do you want to vote on 2606 first if you're referencing it in the
no, we want to do 05 first.
Okay.
next item while he gets that?
What I would if I can just read the whole thing then.
Yeah.
And actually, Judge Kevin, can I borrow section L?
Here's section L.
I'm going to drop that in as I read.
Holden, I do agree that the owner of the preserve acreage should not be responsible for the construction of that fencing.
Yes.
Well, which one?
Okay.
And
Okay.
it's up to the court.
So staff's recommended language would be as follows, and I'm going to start reading at section 4. Fencing of septic system areas located within preserve acreage. Prior to approval of final subdivision plat, all septic system drain fields, replacement areas, and other wastewater treatment facilities located within the preserve acreage or of a rural cluster subdivision shall be identified on the approved subdivision plan and shall be protected by designated fencing approved by the Georgetown, Scott County Planning Commission. The fencing shall meet relevant requirements of the adopted landscape and land use buffer ordinance. The boundaries of all septic systems areas shall be shown on the final plat and on the preserve area management plan. The owner of the, or rather, the homeowners association or other designated entity shall be responsible for maintaining the required fencing in good repair. The required fencing shall be removed, relocated, or substantially altered, or shall not be removed, substantially altered, unless approved by the Georgetown Scott County Planning Commission, and unless equivalent protection of the septic system in a replacement area is provided. And then it would continue as written. And so that removes other barriers and substitutes in the requirements and makes it clear that it's the homeowners association.
So he's recommending this amendment. We will vote tonight in a first reading if the court wants to consider this. And then in the second reading, we'll have it exactly spelled out, exactly as he just presented it. Everybody good on that?
Can I ask a quick question?
Yes, David.
Because we've got a 2605, two 2605s on the agenda. So is this actually 2605 or?
I think you've got a...
One's a resolution.
Oh, it's a
Resolution.
Oh,
26
resolution. Okay, I
ordinance
just saw, sorry.
All right.
So this whole point of this is to keep people from driving on the septic field.
It's to protect both parties. And that was the whole thought process, to respect the concern and protect both parties.
That's fine. It just seems like a lot to, it seems like a big fence to just stop somebody from driving over a septic field. It's just my thought process.
The barrier between the cluster lots and the preserve tract will already have this fence installed because it will transition from the A5 part of the cluster to the A1 part of the preserve. And so really, in the way I'm envisioning this fence would just continue. And then it just incorporates that acreage.
And that makes sense.
Yeah.
In the case of a community lagoon, it has to be 6 foot anyway, correct?
That'd be a WEDCO standard, but yeah.
So, okay. So with that said, where were we? So we've got an amendment, and did we have a motion or a second? We have a motion.
I will second, and I would like to say I like this new conservation easement, whatever we're calling this thing, acreage rural cluster preservation. I was very hesitant about voting on the cluster stuff before, but I like this. I think it adds a lot of stuff that people had concerns about.
So now Ben's going to read the summary, and then I'll need y'all to make those motions.
Okay.
In second.
Scott County Fiscal Court Ordinance Number 26-05, an ordinance pertaining to preserve acreage on rural cluster subdivisions. Summary, number 1. Pursuant to its powers under KRS 67.083 sub H and KRS 67.083 sub K, enacts regulations pertaining to the preservation of agricultural land and maintenance of septic systems on preserved acreage of rural cluster subdivisions. Number 2, requires that all preserved acreage on rural cluster subdivisions shall be permanently protected by a conservation easement. Number 3, requires a maintenance assurance mechanism in the form of a bond or other financial guarantee for the purpose of inspection, maintenance, repair, replacement, pumping, and operation of any septic system or wastewater treatment facilities located within the preserved acreage of a rural cluster subdivision. Number 4, requires a preserved area septic system maintenance master plan for rural cluster subdivisions. Number 5, requires fencing or other barriers for septic system areas located within the preserved acreage. Number 6, provides that if any section, subsection, paragraph, sentence, clause, phrase, or a portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. Number 7, grants the Planning Commission discretion to make non-substantive revisions as necessary to ensure internal consistency, clarity, and conformity with adopted formatting standards. Number 8, provides that all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Number 9, takes effect upon passage and publication. The full text of this ordinance is available for examination at the office of the Scott Fiscal Court Clerk, 101 East Main Street, Georgetown, Kentucky, 40324.
And whoever is willing to make a motion, please make a motion that that you're making it with the amendment recommended by staff to Section 4, page 5, about fencing.
I don't know if I can repeat all that. I make a motion to approve as amended on recommendation by staff.
Section 4, page 5.
Section 4, page 5.
I will second, and I will say again, I had a lot of reservation about the cluster development. I really like this preservation ordinance that we've come up with. I think it answers a lot of questions and issues, trying to listen to people. So I'll second, this will allow me to vote for the cluster.
Any other comments? Questions?
Page 5, number 4.
Page 5, number 4.
It's page 5, number 4. I'm sorry.
I'll amend my motion.
Yeah.
I'll amend my second. Page 5, number 4.
I'm backwards. All right, with that said, we have a motion, we have a second. Any other questions or comments?
Just to go along with what Ryan just said about these kind of changes, the big deal for me too is the fact that we're going to actively come back and look at this within a year.
July of 27.
Then we're going to find out if we've even had any applications, and maybe we will. Right now, we're preserving nothing because there's nobody operating under the current
And you know the thing about it, Rick, is I think everybody will be looking at the same court.
What's that?
Everybody will be looking at the same court a year from now. So we have no excuse for not coming back to it.
We'll come back. You know that. So with that said, all those in favor, please say aye.
Aye.
Any opposed? No. Have a no from Mr. Magistrate Jones. All those, it passes. We'll move to second reading. And then next is 2606, first reading for the clustered subdivisions as presented and shared already. I'll ask Mr. Willis to share it.
Happy to. Scott County Fiscal Court Ordinance Number 26-06, an ordinance amending the subdivision and development regulations in Scott County and the Georgetown Scott County zoning ordinance regarding cluster subdivisions. Summary, number 1. Pursuant to its powers under KRS 67.083 sub K, adopts the recommendations of the Georgetown Scott County Planning Commission following a public hearing on April 9, 2026 for amending the subdivision and development regulations in Scott County and the Georgetown Scott County zoning ordinance regarding cluster subdivision. Number 2, amends the subdivision and development regulations to add definitions for, quote, American Association of State Highway and Transportation Officials, end quote, quote, institution of transportation engineers, end quote, quote, traffic impact study, end quote, and, quote, Kentucky Revised Statute, end quote, and amends the definitions of, quote, agricultural or horticultural use, end quote, and, quote, cluster subdivision, period, end quote. Number 3, amends the subdivision and development regulations regarding cluster subdivisions to address cluster development density, lot size, preserved acreage, planning commission review, septic system, maximum number of cluster lots, access points, individual lot standards, parentheses, size, width, setbacks, parentheses closed, roads, required landscaping, buffering and fencing, water supply, fire protection, plat requirements, restrictive covenants, deed restrictions, fences, soils, and homeowners agreement, period. Number 4, amends the Georgetown Scott County zoning ordinance to amend the definitions of, quote, agricultural uses, and, quote, cluster subdivision, end quote. Number 5, provides that if any section, subsection, paragraph, sentence, clause, phrase, or a portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. Number 6, grants the Planning Commission discretion to make non-substantive revisions as necessary to ensure internal consistency, clarity, and conformity with adopted formatting standards. Number 7, provides that all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Number 8, takes effect upon passage and publication. The full text of this ordinance is available for examination at the office of the Scott Fiscal Court Clerk, 101 East Main Street, Georgetown, Kentucky, 40324.
Questions or comments? Would there be a motion?
Motion.
Motion from Kelly Corman. Would there be a second?
Second.
Second from Ryan Pratt. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? No. Motion passes. We'll move on to second reading with all 3 of those, and we'll make sure that 2605, we correct or amend the language to reflect what was shared tonight. Resolution 2605, Ben, will you read that resolution, please?
Absolutely. Scott County Fiscal Court Resolution 26-05, a resolution amending Resolution
2603.
Thank you. 26-03 relating to the creation of a moratorium on the Georgetown Scott County Planning Commission's acceptance and review of applications for the establishment of data centers. Whereas on March 13, 2026, the Scott Fiscal Court adopted Resolution 26-03 establishing a temporary moratorium on the Georgetown Scott County Planning Commission's acceptance, processing, and approval of applications for the establishment of data centers, and whereas Resolution 26-03 provided that the moratorium would expire 6 months following its adoption unless terminated earlier by action of the Scott County Fiscal Court, and whereas the Scott County Fiscal Court finds that additional time is necessary for the Georgetown Scott County Planning Commission to continue researching the impacts of data centers, conducting public hearings, evaluating regulatory alternatives, and developing appropriate recommendations concerning land use regulations applicable to data centers. And whereas the Scott County Fiscal Court further finds that extending the moratorium is necessary to preserve the status quo while such review and evaluation are completed and to protect the public interest in orderly planning and development within Scott County. Now, therefore, be it resolved by the Scott County Fiscal Court as follows. Section 1 of Resolution 26-03 is hereby amended and restated as follows. Quote, that there is established a moratorium on the Georgetown Scott County Planning Commission's acceptance, processing, and approval of applications for the establishment of data centers. The moratorium shall take effect immediately upon adoption of Resolution 26-05 and shall 26-03. Which one should I use there? 05. And shall automatically expire on December 31, 2026, unless terminated earlier by action of the Scott County Fiscal Court. This moratorium shall apply to all zoning approvals, development plan approvals, conditional use permits, building permits, and other authorizations related to the establishment of data centers. Number 2, except as expressly amended herein, all provisions of Resolution 26-03 shall remain in full force and effect. Number 3, this resolution shall take effect immediately upon its adoption.
25th of June 26. Any questions or comments related to this resolution? Would there be a motion? Motion from David Livingston.
Second.
Second from Rick Hostetler. Any other questions, comments? All those in favor, please say aye. Aye. Any opposed? Motion passes.
Judge, I do want to make a comment that I was in a community today, and I hope our community knows that a moratorium means that they're not going to be accepting applications, because there was a community that they blew up on Facebook because they thought it was to allow them to come into the community. So,
No.
just in case anybody's out there that doesn't know what a moratorium is.
No. No, shall not accept any application. So,
Thank you, Dave.
appreciate that. Now, July meeting date and time. Need to ask, first and foremost, July 3rd, we are closed and we have a work session scheduled for that. I would propose that we cancel the work session. Anybody?
So moved.
We have a motion? Second. Any other questions or comments? All those in favor, please say yes.
Yes.
Any opposed? I'm getting tired. All those in favor? Aye. Any opposed? So motion passes to cancel the work session. The next question, I have additional information to share. We have a business meeting on July 10th, and I had shared that both Cam and myself are going to be out of town on the 10th, but additional information, the chiller that is located out here that's part of this HVAC renovation process, it's going to be completely, the chiller is in, and on the 10th, they would like to shut down the courthouse, shut off the electricity, and shut down Court Street for half a day at least to install the new chiller. So I would propose moving the 10th business meeting to the 7th, as we discussed. We'll still have to pay bills and process stuff and have a small agenda, but would there be a motion to do that? Motion from David Livingston, second from Rob Jones.
In the morning, like at
9 a.m., yes, sir.
The chiller's working right now.
Yeah, so any other question or comment? All those,
Rigged it up for just tonight.
we've rigged it up for just tonight. And it's using the old chiller. But all those in favor, please say aye. Aye. Any opposed? Motion passes. So that is addressed. That the next item is, we'll just have to close the courthouse, and I've already spoke with staff from the clerk's office about communicating that vehicle transfers will happen at 240 Caleb Conley Way. I've spoken to the PVA. He most likely will have staff work remotely, and we'll have our second floor staff work remotely as well. And we'll still answer the phones. Jared will answer the phones, and we'll still address concerns, but we'll have to post and share that the office at 101 is closed that day. So any questions or comments about that? I don't think we have to vote on that. And then next is new business. I have two change orders. The first one has to do with condensate pumps and for this building, for the HVAC project from TP Mechanical. And that change order is for the installation and labor for the electric side. There's really two sides to it. The $18,308.34 for the labor, material, and direct expenses, bond, and overhead profit. That's just to TP Mechanical. Then the other piece of it is $7,500 for the electrical installation and connection of the condensate pumps. So that's all together. That's change order 2 or 3, I think. So questions or comments about that change order?
First of all, Judge,
You need to recuse yourself.
I'm going to recuse myself for 2 reasons. One, the design team is the same design team on a school that I'm building in Lexington. And 2, the electrical contractor that's got that proposal is my son. So,
And that proposal is through the winning bidder.
correct.
And so we've got any other questions or comments?
I might comment. So I spoke with somebody today, and the problem is that the condensate units that they put in, the new condensate units are lower than the older drain lines that they had on the old units. So now they gotta take the water from here, pump it back up to this drain line. So that's the reason for the condensate pumps.
So you answered the question I had then, because I
I'm
was.
always in favor of positive flow.
But the cost to move all those lines
Right.
would have been more expensive.
And they didn't account for that when they did the bid, they just didn't.
Yeah.
So I'll make a motion.
Motion from Rob, second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Now, the next change order, the new lighting was part of our bid package. We didn't include any dimming or any of that. I'm going to table the second change order because I want to get some more information, and we'll bring that information back to you all. But unless somebody disagrees, I would prefer to wait on it. And it can be done at any time. But the other piece, they're working on it as we speak. So I'm going to table change order 2 on the dimming piece of it. And we'll come back. And then at our last
question,
yes.
just so we make sure we do this right. When you say table it.
We're not tabling.
Okay, we're not tabling. We're not going to vote on it. I apologize. Thank you. We're just not going to vote on it. And then the last thing I have in new business, unless someone else has new business, is at our last meeting we discussed the need at planning and zoning for a new roof, a partial new roof, but we did not take a vote on that, and I would like to vote, and the got the daggone piece of, let me find it, here it is. So the recommendation from JR was Pickett's Roofing estimate at $38,030 to replace the flat roof section with .60 white TPO commercial roof system using mule hide or Versecchio. So that was the recommendation. Would there be a motion? The Pickett's Roofing bid.
Planning and zoning.
Yeah. So we have a motion from Rob, a second from Rick. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. I have no other new business. Anybody else have any new business? Anybody else? Is there a motion to adjourn? Motion, second. All those in favor, please say aye. Aye. We are adjourned.
Assuming that motion was Kelly.
You assumed correctly.